evening. Welcome to the November 30th, 2015 Board of Appeals open meeting. I'll take a second to introduce everybody and ask the public to silence your cell phones in the meantime as well. I will introduce the board. To your far left is Ken Foreman. He is Vice Chairman of the board. To my right is TJ Hurry. He's the clerk of the board. Next in line is Ed Van Kuren. He's a regular voting member. To his right is Paul Murphy. He's a regular voting member. Sri Budrow is at the end. She is the zoning administrator. And Mark Bobrowski is also present. He's special counsel to the zoning board. The Zoning Board of Appeals is charged with applying the zoning bylaws for the town and considering requests for special permits, variances, and appeals as provided in the bylaws, which have been approved by town meeting and the Attorney General's office for the Commonwealth. Tonight, we just have open meeting. So the two matters that we'll be discussing are appeal number 6815 and appeal number 7015. The public hearings on both of those matters have been closed, so we won't be accepting any more testimony. This is just for us to discuss what's been submitted already. I would also just like to ask anybody videotaping if they could, or recording, if they could just identify themselves at this time. Thank you. Could you just provide your address too for the record? Thank you. Anybody else? No? Okay. All right. So we should start our discussion.
I sent you an email today through Sri and the chair, and it's filled with questions about Win 2, but we have one remaining issue with regard to Win 1. If you remember the framework here, Attorney Senni filed two individual appeals, one for Win 1, one for Win 2, seeking enforcement of the zoning. We have already decided his Win 1 matter some weeks ago, and that was, we concluded that. Mr. Watt took a different procedural step here. He appealed both in the same letter, and so we've not yet deliberated his Win 1 portion of his appeal. And then, of course, going on to Win 2, the second portion of Mr. Watt's letter was about Win 2, and Mr. Senni filed a separate Win 2 appeal. So I guess the easy question for the evening, or I'm thinking that it might be easy, is what do you want to do with regard to Win 1? Do you want to simply do what you've done already, or is there some reason why you would want to, in the context of the Watt appeal, why you would want to re-examine that question in any way?
I mean, I know I'm comfortable moving forward with what we had done previously.
I am as well.
We have,
Sure.
I don't think there's been anything submitted to change.
Yes.
Why don't you have somebody make a motion to that effect? Of course, it would be also subject to Mr. Sousso's letter of October 6th with protocols for maintenance during the shutdown period.
That would include that.
I would include that
Yes,
this
yeah.
time in the decision, so I don't have to write another letter to
Yeah.
Lottie.
Yeah. We go along with that.
Okay, so does anybody
I
want
make a
to?
motion.
So that was Mr. Van Kuren. Second.
Sure.
Do you want to elaborate on what that actual motion would be, please?
So that is application number 6815 as to Wind 1, that we, deny, wait, no,
There's a-
sorry. Approve.
Hold the appeal,
Uphold
right?
the appeal.
And request that they cease operation.
Yes.
Which
thank
they've
you.
done already.
Right.
So I would take the material that has already been framed as the decision for Wind 1, and I would put it into the first half of the decision, the Wind 1 portion of the decision on Mr. Watt's appeal.
And include the part about maintenance.
Yep.
Okay, so Ed made the motion. Is there a second?
Second.
Okay, so that was Mr. Van Kuren and Mr. Murphy. All those in favor?
Aye.
Aye.
And I'll vote against on this one as well, since that's what I did last.
So 4-1?
Okay, with regard to Wind 2, slightly different, quite a bit different procedural posture. Wind 1 already gone through the appeals court by the time you made that decision and reiterated it tonight. Wind 2 has not gone to court at all. So we first of all have to ponder whether or not the parties that were identified by Mr. Senni and Mr. Watt have standing. And this is a matter that sort of sits with the case all along. Standing can be raised at any time. It can be raised at the Board of Appeals. It can be raised at the trial level. It can be raised by the appeals court. It could be raised by the court without any lawyer pointing it out. And typically, I would call standing is equal to the aggrieved person status. In order to file an appeal under sections 8 and 15, you have to be an aggrieved person. So an aggrieved person typically is somebody who suffers a harm or an injury, which is different than that suffered by the general public. And a typical injury would be traffic drainage. In this context, it would be noise or flicker, more particular to the type of activity being conducted. So think about who the people are before you in both the Senate and the Watt appeals, and ask yourself with regard to each of them, do they have a particularized injury of the sort protected in your ordinance, or I'm sorry, your bylaw?
Does anybody want to start a discussion on that?
Let me just put these in a proper framework. All these questions that are at the beginning of my email to you are threshold questions. If they trip up on any of these, then we don't get to the merits of the decision, should we enforce.
I mean, it's my position that these folks that are being represented by the two attorneys have standing. I wouldn't want to, I really wouldn't know. I'm going to assume that they have standing. I'm going to assume that they have standing because, I couldn't pinpoint that they don't. I personally would stay away from that personally. I'm more comfortable with, a judge making that determination. So my position is I'm going to assume they have standing.
Okay.
I don't want to be the judge of that at this level.
So, I mean, my view is they have proximity, right? That's the first criteria you might apply there. There's been testimony that they're impacted by flicker and noise. To me, that's justification for considering that they have standing.
Right, and I know at the last hearing, there was some question raised by the town as to Neil Anderson specifically, if he was more affected by Win 1 versus Win 2, and we definitely heard testimony that he is affected by Win 2, and he does have the proximity, like Ken said, so I think it would be premature to say that they don't have standing at this stage. So.
Yeah, I would call to your attention that section 240-166 does create an interest in being free from television interference, ice throw, prop throw, noise, etc. So that is a claim that they can make for standing. Obviously, if they got green cards in the mail with certified mailing for the public hearing, they have a presumption of standing. It recedes, the presumption recedes if the issue is contested. It's always their burden, however, to prove that they do have that particularized injury. It's not the town's burden to prove that they don't, it's their burden to prove that they do. So to keep it in that framework as well.
So does anybody else, Ed or TJ?
I mean, I generally agree with you and what Ken said about standing.
Yeah, I mean, that's an interesting point Attorney Bobrowski brings up, that they were on the mail, at least for some of these mailings, they were on the mailing list.
The only mailing list that counts for the presumption is the assessor's list that went out when Cerise sent the notices of the public hearing. That would make them parties in interest under Chapter 48, Section 11. A party in interest is an abutter, an abutter of an abutter within 300 feet, or a person who is across the street directly from the project. Sometimes the assessors err and send out many more notices in the interest of caution, but the party in interest standard for standing is abutter of an abutter within 300 feet or directly across the street. That's what the statute says. It's sometimes people more distant have standing. There are cases in which people 8 houses away, so they don't qualify under that definition, nonetheless still have standing. Parties seeking to uphold the integrity of the district in which they reside have standing in some cases, but I don't think any of these parties reside in the district because it's a public use district. It's not a question that goes away with your decision tonight. Like I said, even if you decided unanimously that they have standing, it doesn't mean that the town can't raise the issue in court and that it won't be litigated again in some other place.
Right.
Do you want to move beyond that, or are you all comfortable with that?
Is everybody comfortable?
Yeah, I'm comfortable with that.
Ken, you sounded comfortable? I think
Yeah.
you're comfortable.
Want to do it on a motion?
Sure. Does anybody want to make a motion to that effect, that the parties before us, we find that they have standing?
I'd like to make a motion that the parties before us have standing.
Okay, that was Mr. Murphy, second?
Sure.
Okay, and Ken. So all those in favor?
Aye.
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 Unanimous.
Okay, now we're down to the beginning of the time period in which an appeal might have been filed. My understanding is that the building permit for Wing 2 was issued in March of 2010. If I remember the dates, it was March 18th. And Wing 1 construction started? It would have had to have been construction. Started 5 days later on March 23rd. So the Gallivan case, which was brought to your attention, was one from Wellesley in which the town has a peculiar requirement that when a building permit is issued for new construction, it goes out to the neighbors. Otherwise, the State Building Code and the Zoning Act do not require notices of building permits to be sent out. And the court ruled in the Gallivan case, when you got notice and you didn't appeal within 30 days, you lost your rights. Otherwise, you would have rights under the 6-year statute of limitation that's set forth in Chapter 48, Section 7. So the alternatives then are pretty clear-cut. If you have notice of the building permit, in the Wellesley case, you got it because it was sent to you by the town, unavoidable, then you lost your 6-year rights to seek enforcement. You don't have 6 years to appeal the building permit. If you don't do it within the first 30 days, it's the other side of the same coin. You can seek zoning enforcement. That building permit should have never been issued. Just enforce the zoning. But if you had notice in that 30-day period, you had to take advantage of it and file your lawsuit. So that's the first case. The second case is Connors. In the Connors case, the person in question was in town hall, and somebody said, hey, the building permit was issued for the guy next to you. I think he'd lost some portion of the 30 days already. If I remember correctly, it was on the order of a week or 10 days had gone by. But instead of appealing in the time remaining in the 30-day period, he waited until it was over, and then he appealed 10 or 12 days after. And the court said, you had notice, you had to appeal. The third case is the Richardson case, in which she followed his building permit activities for the better part of a couple of years, had gone to Conservation Commission hearings, and pretty much was an interested party in terms of what was going on next door. But she waited and didn't appeal the building permit in that 30-day period. And the court said, you had, as a person of interest here, a duty to inquire, and you basically didn't do it. And so therefore, your 30-day period is gone. You don't have the 6-year statute of limitations. So you have to try to decide what happened. All we're focused on right now is the 30-day period from March 18th to April 18th, plus or minus a day. And the question is, should they have appealed the building permit within that period? It's not about when they knew, did they appeal it within 30 days? It's about the first 30 days. That's all that this question is about.
So, but that hinges, if I'm understanding, they have to have knowledge.
Yes, they have to have notice. Either they have to have actual notice or legal notice because somebody sent it to them.
So in the case of Okagawa, I was quite convinced that by the affidavit, her testimony, that she didn't have knowledge. And she was upfront that Win 1 she had no issues with Win 1, and why would she suspect any further problems? So for me, that was, for the first 30 days, it was clear.
Yeah, I'm assuming they didn't know either. I deal with this a lot. I think the general public is generally kind of ignorant to this stuff. They're not aware of permit process and appeals, and they wouldn't have known that. And so I'm just going to assume also that they didn't know that the building permit was issued. Within 30 days, did they have direct knowledge of that? I would say probably, if they're representing that they didn't, I would say that's probably believable. I see it a lot in what I do for a living, where the general public has no idea of how building permits are issued, their time frames, or anything like that. So I agree with Ken's analysis as well about Okagawa. So, yeah, I'm going to assume that they did not have knowledge of the issuance of the building permit.
When you say that you assume, I just want to make sure that we're basing, you're saying that she didn't have knowledge because, and I apologize, kind of
No, that's all right.
further down my backs too, that based on the evidence that's before us, that there's no evidence that she had knowledge or that she
Yeah.
had a duty to inquire as to Okagawa.
Yeah, I'm not so sure on the duty to inquire. I'm not putting a lot of weight on that.
Why would she have a duty to it?
Yeah, I'm not putting a lot of weight on
No,
that.
but that comes, that's
Oh,
part of
yeah.
the inquiry.
Right.
The point is, she, by the affidavit and the testimony we've heard, she had no issues with Wind 1.
Right.
So therefore, why would she inquire? In fact, again, it wasn't until, if we believe the timeline presented to us, until October 2010, when she was informed by a neighbor that Wind 2 was even going up.
Right. Yeah, no, based on the testimony, I'm, making my assumptions on that, but, yeah.
What about the others? How many total appellants do we have with regard to Wind 2 seeking enforcement?
You have the Okagawas, Andersons, Funpars, all of them.
Yeah, I might be less convinced on the others. I mean, I don't know that we heard much affirmative evidence one way or the other on the others.
Right, and I remember asking Attorney Watt specifically about the Andersons. Well, when did they know? And there wasn't an answer provided.
And
And they definitely knew about Win 1, so.
they knew about and were disturbed by Wind 1.
Right.
I have a feeling that everybody in town knew about it. With all
Well,
the
2010,
publicity.
remember?
Yeah, but
This is
all
a
the
while back.
publicity that was in the papers, town meetings, all this other stuff. You can't believe somebody would not know that those things were going on over there.
Knew 1 was going up. Did we know 2 were going up?
I think there was enough information overlapping about both of them, that if you were paying attention, you would know.
So let me be clear in terms of going forward. If 2 of you think that all of them knew or should have known, then we're going home. If all of you think they had no way of knowing or any duty to inquire, we move on.
And again, you're talking about the 30-day.
It's just about the first 30 days. The period from, I believe it's March 18th to
April.
the April 17th, 2010.
Well, if Okagawa's appeal
It's a separate appeal.
is a separate
right?
appeal. So if we think she didn't have knowledge, she had no duty to inquire, then we can move past that question.
Yep.
And then as to the other ones, if we thought they might have a duty to inquire, or that they did in fact have a duty, then we could make that, so we could still reach the second question as to,
Yep.
okay. So Ed, you say you think everybody should have had knowledge.
Yeah, I mean, with all the information that was in the newspapers, and it was more than one newspaper, I would think everybody in town would know about that.
About this, well, no, it's not just knowledge that well, I suppose it's a duty to inquire
Yeah.
about the second wind turbine.
Yeah, but again, regardless, so let's say, imagine for a second that you did know a second wind turbine was going up, but the first wind turbine didn't bother you. So why would you make any inquiries about the location of the second one?
I think it
You're
was-
going to location. You could know that a second wind turbine was going up, but if you don't think it's necessarily going up next to you and going to impinge on you, you might not make any inquiries.
I think there was enough complaints just generally about wind turbines that would overflow in your mind and say, gee, maybe I should pay attention to this.
Unless you were in a butter who wasn't experiencing any harm, in which case you might say, fine, I'm okay with it. Then, at some point, it goes up and it begins to bother you.
It's not notice of harm, it's notice of the building permit.
Strictly the 30 days we're talking about.
I agree with you that it might be difficult for somebody to say, in that 30-day period, if I don't appeal this, I'll suffer harm, or what the harm will be and the degree to which it will impact them. But the key to knowledge is the knowledge of the building permit.
Okay, so want to take them one at a time. So we said Okagawa. So Ken, you said no knowledge, no duty to inquire.
With respect to Wind 2.
With respect to Wind 2 for Okagawa.
That's
Why
my
not?
view.
Let's do them one at a time. TJ,
I'm with Ken when it comes to Okagawa and 1, 2.
okay?
I'm sorry, I didn't hear
I
you.
didn't,
He's with Ken.
Sorry, I'm with Ken. No notice and
Okay.
no duty to inquire.
Obviously on the other side.
Ed's on the other side.
Yeah.
Paul, you say?
I'm with Ken.
And I am with Ken as to Okagawa. So that is
We're moving on.
4 of the 5, so
Yeah.
we'll be moving on with that one. The
Otherwise,
others.
are you sticking to that?
Yes.
So it's 4 to 1?
Yeah.
Okay. And you might as well do the others.
Right. Which I think presents a stickier question based on
Right.
the evidence that's before us.
Let me just see if there's any information as to the first complaints on Wind 2. Wind 1, I'm sorry, were as early as June 2010 that I'm finding.
I thought that there might have been complaints before that as to Win 1. Anderson Law complaint regarding Win 1 on March 30th, 2010, I have written down.
Okay,
So that's clearly within the 30 days.
This is
As
from-
to Win 1.
this is a email from Mr. Funfar that I'm looking at, but yeah, okay.
So at that point, did they have a duty to inquire as to Win 2, as to a building permit? Whether or not they knew about the building permit, but did they have a duty to inquire once?
Are there any more of these things going up?
Yeah.
Well, in the Richardson case, the other activities on the site, the other permitting activities, were what created the duty to inquire about the building permit, or the duty to know in that case about the building permit. So they needed multiple approvals on the Chilmark property.
What, I guess this, I don't remember if we answered this. When did the building permit for Win 1 issue? Was it the same, so that if somebody was going to see if a building permit for Win 1 had issued, they would also have seen that Win
it was
2 issued?
2008,
I don't,
wasn't it?
Do you know, Siri?
I thought it was 2008. The files are right there by TJ. It should state, especially in all the minutes. I know it's stated in the Anderson 2013 hearing, but it should be in the file. I want to say May of 2008.
so you see some, either way, you see something going on the site. You go to the building department. At that time, you would presumably see that there was another building permit that had issued.
Would you?
It's for the same property. And you weren't calling, right, they weren't necessarily, or were they calling it Win One? Wasn't there some
They
conversation
were calling
about
it Win
that?
One.
So, that there might be a second wind turbine.
So I guess one argument would be, well, if they're calling it Wind One, then I think this argument was made, wasn't it?
Mm-hmm.
There must be a Wind Two.
But I think it also cuts against it, because if somebody went and said, what's in the file for Win One and didn't ask about Win Two, then perhaps they wouldn't
Right.
know. Any other thoughts? So, Ed, I think your position on this is the same.
Yeah, well, yeah, definitely,
Yes, definitely.
yeah.
Okay.
Are we talking about the Andersons right now?
The Andersons, yes. Paul?
Yeah, the question is whether or not he should have had a duty to inquire.
Whether they had knowledge of the building permit or they had
Yeah.
a duty to inquire.
Again, from my experiences and from the testimony, I believe I don't really believe anybody has a duty to inquire. A duty to inquire, so, because, people are busy, we go about our lives, you see site work going on or you don't, or I don't think anybody has a duty to go to the building department and say, what's going on down there. Some people do, I take those phone calls.
But, well, I think the case law says that in certain circumstances, you
Yeah.
have a duty to inquire.
I know,
The courts
but-
are clear about
It's
that.
a legal issue.
So,
Yeah,
It's a legal rather than a moral issue.
yeah, no, I know, a duty, so I'm bound by that, I guess.
no, it's whether or not the Andersons, taking the legal standard, whether or
Right.
not the Andersons in this circumstance, given the information that you know, looking at, how the courts, I guess, have analyzed the issue.
Here's what I don't
previously.
understand, is the Andersons made lots of complaints and wrote letters regarding Wind One. Why didn't they do that for Wind Two? Why didn't they also say Wind One and Two?
Mm-hmm.
Until now.
Well, that would go to their standing, right, where they agreed by Win Two.
Well, okay, you could look at it that way.
There's a timeline if it helps, I don't know. If you have the
Timeline.
material, oops, there goes something.
Yeah, we have a partial
Okay,
timeline.
here's a timeliness and latches timeline, if you want to look at it. It's in the materials Mr. Senni gave, dated July 28th.
Right, but that only goes to October 2010, correct?
Yeah, but it covers our first 30-day period.
Right, I understand. Yeah. And I don't know that it. So according to this May 5th, the elders requested that Wind 2 be stopped on May 5th.
So they had, obviously, knowledge of Win Two on May 5th. Actually, I'm sure before May 5th, because
Right.
they met with the assistant town manager on May 5th. So I guess that goes to Ed's point, that there may have been a general, or probably
Yes.
a general knowledge, at least to people who were being affected by Win One, about Win Two.
Of course, May 5th is after April 18th.
It is. But the Win One began operating April 6th. So that still leaves 12
April
days
6th.
if you were concerned.
Yeah, that 12 days, how is not an enormously long period of time to experience something, to know whether you, maybe you think, they're just starting up, it's it's going to get better.
But the first complaint was March 30th, even prior to them operating consistently.
Yeah, it's still short.
It's unfortunate that the case law gives us only one person to examine the conduct of in Chilmark, who had, hung around this for a long time and obviously missed the deadline. So I think what you have to do is sort of compare. I think you have to ask yourself, what would a reasonable person have done within that first 30-day period?
This is a little different than, say, a structure going up where the structure's there. This is a response to the operation of something, right?
Mm-hmm.
Well, and it wasn't even, when
Con-
2 wasn't operating.
Well, that's for sure true, but
And wasn't
in this
being
case-
constructed within that period. So you don't really have a sense of location until it was
Mhm.
constructed. So, and I know that the town, I think Attorney Tillotson kind of concedes, well, do not contend actual notice by the parties. So they're not saying they actually knew, they're saying they had constructive notice. And I think she pointed to the list of abutters, the Energy Commission updates, which I think there was some question. I know the abutters I shouldn't be saying abutters, but the people on that list contend maybe they didn't receive that.
Would it help if I read Richardson's facts and you could then compare them?
couldn't hurt.
A party has constructive notice when the evidence is, quote, "sufficient to place on that party a duty of inquiry regarding the building permit's issuance. The following undisputed facts lead us to conclude that although difficult questions concerning the adequacy of notice may arise at the margins," that's a quote from Connors, "Carlin had constructive notice of the issuance of the permit on September 11th, 1999. By that time, this is what had happened, Carlin had hired an attorney to assist with her opposition to the proposed construction on the Cohen property. By his own admission, the lawyer had seen plans of the proposed construction, had been intimately involved in all the proceedings and met with members of the town. Carlin had vigilantly monitored Cohen's plans for construction and fought his efforts at multiple steps. In April of '99, for example, she filed a complaint in the Superior Court appealing the issuance of a septic system upgrade permit. In the complaint, Carlin acknowledged Cohen's plan to build a large single-family dwelling. These undisputed facts establish Carlin's awareness of Cohen's intention to begin construction as soon as possible.
I don't think we have those facts here. I think there were complaints lodged during the period, some complaints about Win 1. But I don't think that we have facts before us.
I guess what's bothering me is if someone is putting up a structure that you deem encroaches or, there's some reason why it shouldn't be there, it's in your right of way, whatever. That's very clear cut. The structure is going up, you object to the structure itself. As opposed to some result of the use of that structure subsequent to its construction. So, yeah, the wind turbines look great. I'm all for green power. Then they go on. My God, these things make noise. They're bothering me. How constrained are we by this time period? Because I don't know that it's an appropriate time period.
Well, look, the facts of the matter are that they did not get actual notice because nobody mailed it to them. They didn't walk through town hall as Connors did and get notice in another fashion. And the behavior of Carlin in the Richardson case was what it was. I read you what what she did and her lawyer did. So I think the answer is in that basis for comparison. That's the case that says you have a duty of inquiry. If you see the facts in this case as being as compelling, there was a duty of inquiry. If you think that because there hadn't been a long history of looking at this and there was no way to know.
There's no way to know what the impacts were the instant it went up. And even, perhaps, for some weeks after, as, you know, but they're tuning it, they're adjusting the blades, who knows what they're doing.
Remember that there's not only a question of impacts here, but an equally weighty question of the procedures used to put it up. So even if the impacts were not known, the procedure to get the building permit is a separate matter altogether, and it was ultimately decided that a special permit was required.
For Win 1. Not Win 2.
For Win 1.
So how would you guys like to proceed?
I think the fact that there was notice before the first one was built, because they had taken people to someplace in Hull or someplace to just observe things because there was a concern for noise. I would think everybody would be concerned from day one on the first one. If that's a concern, you ought to pay attention if you're concerned about noise.
We've got to focus, though, on the 3 appellant
Yeah.
representatives here.
I think in my position, hearing the facts that you read, again, and I have read the case, but I think when you isolate them, in that case, Carlin was definitely aware that the permitting was coming, that it was coming, and so she should know that any day the permit might be issued and that 30 days starts to run. And here, I don't think from the get-go that people knew that the building permit for Win 2 was going to issue, and I don't think on the basis of the information that's before us that they had a duty to inquire within the 30 days. So
Yeah, I agree with you.
how I'm
I agree,
viewing
yeah.
this.
Again, I go back to, people being unfamiliar with that process, not, I didn't know a lot about these wind turbines when they were going up. Busy. If I saw it, it was in the Falmouth Enterprise. If I cared to look at it, it's very easy for somebody not to be aware of what's going on. So
But if
I
you have
agree with Ken.
construction activities, and I mean,
Yeah, but this is,
these
but,
people were differently situated
Oh,
than
yeah.
us as,
You're talking Anderson. Remember, this is
Right.
Anderson.
these are the Andersons. And
Right.
so they did have complaints as early as March 30th for Win 1. Ken or TJ?
Well, to play devil's advocate a little bit here, we had Win 1 up. Win 2 was coming, and, I know the argument was made, well, if it was Win 1, then that implies that there was at least a second one coming up. Just because you name a turbine Win 1, I don't think that necessarily puts you on notice that Win 2 would be built on the same property, could be another public use district in town. So I'm not sure if we quite get to the duty to inquiry there.
And they were certainly staggered. You said 2008 for the first building permit. It just happened that the second building permit was applied for, and then it wasn't constructed for a period. So the notion that this was an imminent thing or was coming soon, where they should be monitoring it. I know that there was a general discussion in the town, multiple turbines, but to say that was sufficient, that they should be calling every day and seeing
Yeah.
when that permit issued, I just don't think that the facts are in front of us. But I don't know.
No, I'm okay with that. I'm troubled by as I say, why would you necessarily inquire until you knew it was going to have an impact on you? So if you had an open mind towards wind power, you might not inquire until these things went up and started bothering you.
Okay.
So is there,
Consensus here? Or I think Ed's going to be the
Yeah.
outlier, but does everybody else say that the Andersons, and I would think that the inquiry's pretty much the same for the fund powers, but I don't want to speak for other people. I think the Andersons were the first to make the complaint, so if we say they don't have knowledge and there's nothing else in the record to suggest that the fund powers had knowledge or a duty to inquire, I think we can reach at least that question.
Okay.
Well, is everybody there?
Yeah.
So, okay, so I think we know how everybody feels.
So does that apply to both the Fun Fires and the Andersons?
It does for me.
For me as well.
Yes.
Okay.
And Ed says they should have known.
No, I'd say.
They should have inquired.
Everybody should have said something. To me, there was a raft of information available in the public domain. And if you were concerned about your own health, I think I would have been looking in the paper every Friday or whatever day the enterprise comes out.
Okay, so that is that question.
Okay, now we move on. I think what I'm recording is 3 decisions by a 4-to-1 vote that neither Fun Fires, the Andersons, or Linda Okagawa had a duty to inquire or actual notice of the issuance of the building permit in March of 2010.
Yes.
Now we look to the back of the period, knowing that there's a 6-year statute of limitations. So the appeal of Win 2 was filed in June or July of this year, seeking enforcement. Is that right, June?
Mm-hmm.
And the building permit was issued on March 18th, 2010. So that's a 5-year, call it 2-month, 3-month gap between the 2 dates. And the question it then raised is the one of the latches. Was that a reasonable period of time?
Can you remind me when Win 2 became operational?
It's February 12th.
Yes,
Yeah,
February
February
of
12th.
2012.
And would you remind me when the first enforcement request was made for Win 1 and the board voted 3-to-1 to require the special permit? I was here for that. Was it 11?
It was 2013.
I think that's
Oh,
right.
no, the first appeal.
I think 2011 is correct.
I believe it was 2011.
Yes.
Let's be sure.
I have to go up to
Is
the office.
anybody sure of the date?
I'm not.
No.
I would check the Anderson file.
Okay.
Do we have a copy of the appeal court's Drummy decision here?
I do
Well, I
somewhere.
might have that in mind.
Everybody's got
I
copies?
think I've got that. Here it is. Is this it? No, that's Hobart.
The one recently, the one in June of 2015. It's in the file.
Is this it?
So
Right
it's
there?
any of my stuff.
No, that's not it.
Yeah.
I've got another.
It's not in those exhibits. No.
That was 54-15, right?
The decision in Drummy was February 26, 2015. The building commissioner affirmed the ZBA on March 3rd, 2011. They actually filed their appeal in August of 2010. It was denied by Eladio Gore on September 24th. And the ZBA, by that 3-to-1 vote, affirmed Mr. Gore on March 3rd, 2011.
So does anybody want to speak about latches? Does anybody have any thoughts on this? I mean, I have thoughts, but
I gave the board all the decisions
Right.
for all of the wind turbine actions. brought forth by Drummy, Anderson, Okagawa, where Wind 1 and Wind 2 were both mentioned through the years. So you should all have that information.
Does anybody want to start the discussion?
No.
Okay. I think, oh, Ed?
Good, no, things will go on for the lawyers.
I mean, I'm happy to start it, I guess.
Yeah, no, I'd like to hear it.
I'm sorry, Ken, that my back's to you.
Don't worry about it.
I think that, I mean, I buy into the doctrine of latches. I buy that they knew that there were, you know, it has a different effect, and that's something that, you know, they argue on one hand to have standing, that this Wind 2 has a different effect on different people. Some people the same, but definitely has an effect on them. And I think even if you say, okay, so they didn't know within the 30 days, they didn't have constructive notice within those 30 days, they didn't have a duty to inquire. At least as to Okagawa, she knew in October 2010, that was clear. So even if you say, all right, she doesn't know about the building permit for a year and a half, well, once that starts operating and she knows of its effect, then you start to question, well, you know, she knows of the effect, so maybe she should bring the appeal. She retained Attorney Senni, I think my notes say late 2013. Still, no appeal was brought. And obviously, council knows that if there's, you know, you could seek an enforcement action. And I credit Attorney Senni because he said, well, maybe this was my slip up. He did say that. And certainly that takes a lot to acknowledge and you know, but I just think on the information that's before us, they certainly did, you know, wait until the Wind 1 special permit decision. And, you know, maybe there's some justification on a personal level. They don't want to incur legal fees or costs. But I also think, you know, Attorney Tillotson's point, well, they could have combined these appeals. You know, and then we'd have an order right now that a special permit's required for Wind 2. And I think the fact that you can combine appeals is present just by virtue of this action. We're considering we were considering three appeals at one time. So, and certainly I empathize, and I think Wind 2 needs a special permit. I no doubt, I think that they need a special permit, and I think that the town has an obligation. Certainly, we talk about good faith to apply for that special permit. But on the basis of this, whether or not the cease and desist appeal can be maintained, I think that they waited too long. Reading through the cases, it says stuff about, you know, 8 months was too long. That was the Allison, I know it's a land court decision, but he said, certainly under these circumstances, 8 months is too long. And that was a seasonal residence. There was some evidence that the people who lived next door were only there seasonally. They didn't necessarily know about where the building was. These are impacts that we've heard affected them every day, and yet an appeal wasn't brought. And I know, you know, Eladio Gore, there's some discussion, well, you know, he said don't bring, you know, I'm not going to do anything about your complaints. Mm-hmm. But Wind 2 is separate from Wind 1, and if Eladio Gore didn't do anything, they could have, you know, flooded him with written letters, and if he failed to act, they could have appealed that to us. So certainly, you know, the burden to some extent is on them, and certainly the town's not, I want to say not an innocent actor. I think, you know, if they need a special permit, they need a special permit. But at the same time, it wasn't the town's obligation to say, just like it wouldn't be any property owner's obligation to say, raise their hand and say, well, ooh, I need permitting. If the people who are affected by it aren't doing anything affirmative. So that's my read of the case as.
Well, remember, this has two parts. Mm-hmm. Was that a reasonable or an unreasonable delay? And secondly, was there a showing that there was some sort of, be sure I give you the correct words from the Myers case. establish the defense, there must be proof that the delay worked some prejudice or disadvantage to the defendant. That would be the town. So you have to have that, too.
So it sort of seems like piling on to me. That's really what it was. Wait until we get the decision from the SJC, and then pile on.
And I would just say I guess to the last point, to establish the defense, there must be proof that the delay worked some prejudice or disadvantage to the defendant. And maybe this speaks to what you're saying with piling on. That was something that I struggled with. I said, well, what's the harm here? But I definitely appreciate, I know Attorney Tilson made some points about that, but I thought the point, so now they appeal 1-2. Now it starts exactly where Win 1 was years ago. And I think given, the complexity of this, and I do think that that's a real harm to the town, that they're significantly staggered appeals. So that I do buy that, and I maybe they would have done things differently depending on when that appeal of 1-2 came on.
Yeah, it's a long time. It's a long time.
It's almost at the, we're approaching the end.
Yeah.
Really, the end of the 6-year period. TJ, do you have any thoughts?
It comes down to whether it's a reasonable delay. The years involved, like you said, we are coming to the end of the 6-year period. On one hand of the issue, I do realize that people don't have unlimited funds to pay attorneys and litigate all these issues, but like you said, at the same time, combining the cases was possible. And, at this point in time, I feel like it might prejudice and have the town at a disadvantage at this point when it comes to ranches.
Ed?
I agree with the two lawyers on this one.
Yeah, I agree. Yeah, that's a long, long time to wait.
Ken?
I'm in accordance with you guys.
Okay.
So by consensus, which is 5-0, you think that latches bars the matter from going forward?
Yes.
Yes, I guess we would say both matters from going forward.
Well, with regard to all three, I
Yes.
guess is the answer.
Yes.
Yeah. Can I ask you to give me a little bit more precision with regard to the harm that you think the delay caused the town? I have to write this up. I want to be sure to capture what you think.
Just want to review my notes.
If you'll recall, Mr. Suso testified at the October 29th hearing, and it's in your minutes on page 2.
October 29 minutes. You're in the file, October 29th minutes. And you also should...
I think I declined when you sent the off. So what, TJ, you have them out?
I only printed last week's because you guys, I thought, had them.
Are you, Attorney Bobrowski, are you referring to the middle section there?
Yeah.
Summer's revenue and expenses, is that?
There was this was all, I believe, taken from Diane's PowerPoint, Diane Tillison's PowerPoint. Should I simply go back to the PowerPoint and refer to it in terms of the economic harm that resulted from the delay, or?
Well, I think that's multi-layered. I guess the economic harm, certainly. The harm that you know, the town, I guess for lack of a better word, I don't defend it, but that there was already an appeal on the basis of similar harms that they could have conceivably, I guess, consolidated and been considered at the same time by the courts. And so that it is an undue burden and harm and prejudicial to the town to have to go and relitigate those same issues. And I know Attorney Tilson also said that they, I guess, I don't know if it was the timing there was some statement that they had entered into contracts, and I apologize, my notes aren't perfect, but, and that they, you know, it's difficult to tell us right now because we're second guessing what decisions they would have made differently. And I think given, you know, certainly the public impacts of these projects, or the 2 wind turbines, certainly they may have proceeded differently. And I think the financials, you know, the legal appeals, I do think that it would be prejudicial and that there would be harm to the town. I don't know if I'm missing anything. I did.
It's spelled out in Julian's October 16th letter.
Yes.
The question is harm to the town?
Yes.
Just more protracted litigation, which is...
Okay, what I'll do is I'll try to capture that by going back through those materials. Your meeting on the 10th, we have until the 23rd. I would like you to have a look at what I write before making a final vote on it. We've been doing this mostly by consensus this evening. So I want you to pay particular attention to that portion of what I try to put on paper and have a vote to accept the language. And if that's the case, that will be your official vote in this matter. If you want me to tweak anything, we'll have another 13 days to do it. You'll need, I won't be here on the 10th, so you'll need to be specific with me about what it is that you want tweaked, and I'll rely on the chair and Sari to get me that information.
Yes, there's one issue that is in my notes, which is that the building commissioner's own letters, which counseled for delay awaiting court decision. How do we...
That's wind 1.
Okay. But that was delay with respect to, I'd have to remember, my notes say, check this out.
And you never did.
If I did, I've forgotten what I discovered. Was that delay with regard to a response to an inquiry about Wind 2, pending the decision on Wind 1? Or was it...
Well, even if it was a response to Wind 2, right? And he said, well, I'm not going to consider this, right? But they're saying it's a separate harm. And a lot of Igor is refusing to take action. So then you can appeal that to our board.
Definitely.
And there was no appeal of that refusal.
Okay.
Right? If it was
Yeah,
Wind 2.
that could be.
And we don't know if it was separated like that.
Mm-hmm.
So let me be clear, while we're just sort of talking this through. That means that the substantive enforcement request for Wind 2 need not be answered. If these threshold questions are not passed with flying colors, you don't get to the substantive questions. Judges don't answer questions they don't need to answer. And if latches prevents us from getting to the payday of the ultimate question, we don't answer.
Okay.
Okay.
Everybody can...
If the court disagrees with us, and they might, they'll remand it, and we'll have to answer the ultimate question. But
I just wish... Yeah.
Okay,
good.
good.
All right, so Adam Costa, my very able associate, will be here on the 10th, and I had a conversation with the lawyers the other day about what will be on the agenda that night. I think you're going to go at 6. There'll be testimony from there will be testimony from a noise expert on behalf of the neighbors, and there will be also present the town's acoustical expert again, and you'll have both noise people in front of you that night. Ask whatever questions you want. We can put that issue to bed, and I think we're toying with coming back on January 14th, just so that we can look at your calendars and let us know if that works.
Okay.
Strictly for that, strictly for the wind turbine.
Okay. Sounds
Great.
great. All
Okay.
right.